You need to turn yourself into the Washington County Jail. I'm not even addressing the attorney issue at this point.
Your Honor.
You have counsel.
And if Ms. Richards is a high-risk pregnancy, then why is she testing positive for drugs?
I still, at that point, don't have any tests. No test, no test, no test. She needs to appear here. She needs to report to the Washington County Jail by 6 p.m. on the 17th of May. That is tomorrow. Otherwise, a bench warrant will issue.
Your Honor.
With no bond.
Your Honor. I have tested since I had that diluted screen.
I don't have any tests. I'm not playing by her rules anymore. We're going to play by mine. I've been as lenient as I possibly can.
This defendant appears to be taking a serious gamble with the court. She has repeatedly pointed to her high-risk pregnancy as a reason for leniency, while at the same time failing to follow the bond conditions set by the judge. Those conditions weren't optional, and they applied regardless of personal circumstances for months. She failed to appear for required drug testing altogether. When she finally did show up, the samples she provided raised immediate concerns because it appeared to have been altered. That moment significantly changed how the court viewed her compliance and credibility up until now. The judge has made considerable efforts to accommodate her situation. He adjusted expectations, showed patience, and gave her multiple opportunities to get back on track. However, that flexibility seems to have reached its limit, as continued noncompliance leaves the court with fewer options. This raises a difficult but important question. Did she believe her pregnancy would shield her from consequences altogether? Courts can consider medical conditions, but they cannot ignore repeated violations of court orders that at this stage. The possibility of custody, even this close to her due date, is very real. So what do you think? Does the judge have the authority to order custody under these circumstances, or should alternative measures still be considered? Let's break it all down and take a closer look at how this situation reached this critical point.
Caitlin Kirby on behalf of the people.
Mike Gaddy, Assistant Public Defender on behalf of Ms. Richards, Your Honor.
Ashley Richards.
Ms. Richards hasn't been testing. What are we going to do on this? She hasn't been testing, and there's a current bench warrant out for her with no bond.
Had a discussion with Ms. Richards. She had expressed some dissatisfaction with my office in general and me specifically. I don't know if she's wishing to ask the court for a new attorney. I do have some information that I can immediately refer to the court, but I didn't want to do that if that's the case, since I wouldn't want to step on a new attorney's toes in terms of what they wanted to do.
And Your Honor, no, regardless of what Ms. Richards' problems are with the public defender, she has failed to report. She's missed several tests starting from February to April 11th, and then was positive on April 17th and April 24th, and she has an active warrant.
As I said, Judge, I have a test as recently as May 2nd that I can provide to the court immediately, along with some other documentation. Again, I just didn't, given the nature of our last conversation, I didn't know quite how to proceed.
Ms. Richards?
Yes?
You haven't been going to testing according to what I have. I've issued a bench warrant out for no bond. You need to turn yourself into the Washington County Jail. I'm not even addressing the attorney issue at this point.
Your Honor.
You have counsel.
Your Honor, as I said, I have a test from as recently as May 2nd from her primary care physician. She is currently in a high-risk pregnancy. I'd ask the court to take that into consideration here. I would have turned those things in, but for the conversation, and I can do that immediately if the court would wish to give us another date. But given the nature of our conversation, I was between a rock and a hard place.
And if Ms. Richards is a high-risk pregnancy, then why is she testing positive for drugs?
Well, I think that would be between her and her physician.
Today is the 6th.
I'm sorry, Judge.
Go ahead.
Oh, I was just going to say this matter's been kind of rendered a little more difficult because she is in Muskegon, and we're here. We did find a testing facility there. There was no sign. It was actually in a law office. We do have some tests directly from her doctor. The crux of this is that there was an offer for use in this matter. This matter was actually charged after it occurred before, but it was charged after she successfully completed probation in Muskegon. I have documentation from Catholic Social Services there that indicates that she did her primary care and then has been continuing with aftercare studiously. That there's that as well. I don't think it's a matter of her trying to flaunt anything, but just there's a distance, there's financial issues, there's medical issues, and there's But I
on January.
Wait a second. She wants to file a complaint against her own attorney because paperwork wasn't submitted on time, even though she didn't provide it when she was supposed to. That's a bold move, especially considering this is the very person trying to keep her out of custody. Blaming counsel for delays that stem from her own inaction completely flips responsibility on its head. What makes it even more awkward is that the attorney is standing there with documents he couldn't file because he didn't receive them in time. Instead of helping her case, criticizing him in open court only weakens her position. Publicly undermining your own lawyer is one of the fastest ways to sabotage your defense. It's frustrating to watch this pattern repeat itself. Defendants pushing away their public defenders, burning bridges, and then acting shocked when their cases start to unravel. Accountability matters in court, and shifting blame rarely works in anyone's favor. This situation really highlights how refusing to take responsibility can turn manageable problems into much bigger ones. That I'm curious what you all think. That I asked this a misunderstanding? Or does it show a deeper pattern of avoiding responsibility? Drop your thoughts in the comments below.
Go ahead. But I'm just going to tell you, on January 26th, I approved that the defendant could test in Muskegon with results to community corrections. I don't have any results. I've been going back and forth. Mr. Gaddy, all along, and I don't know what her deal with your office. You're the only one that's been keeping her out of jail at this point. We further ordered that she could test in Muskegon. She needed to get the number to us. I signed a specific order that PD's office had done that regarding the modification of the location of her testing. We did that that was in late January. We then come through February still, and I don't have any tests. And she has continued not to test. And then I get a report on March 29th. This is some period in time. I still, at that point, don't have any tests. No test. Again, gave her a break. Didn't do it. And then all of a sudden, I get to March 30th. Still don't have any tests. She's not here. And I issue a bench warrant. Bench warrant's been out since March 30th. Again, trying to get tests. Still don't have any tests. Nothing. We've just been continually putting it over. She decides she doesn't want to test. And then I all of a sudden get a test in April that indicates that she's then positive for THC. And then on the 24th of April, that the specimen has been diluted and there's been some adulteration of that specimen test. That was on the April 24th test.
Yes, Your Honor.
We were here on April 27th, and I still don't have tests.
Yes, Your Honor. As I said, I do have a test from May 3rd, from her physician. I can forward that. I believe I also have tests dating back as far as last year that I received this afternoon. I also have a letter from Catholic Social Services. If perhaps, if I'm still on the case, I'd be happy to submit those things. If the court would consider setting this over for Thursday week, which I think is the next preliminary probable cause date, I can certainly send those documents.
Mr. Gaddy, I understand what you're indicating, and you've been trying to make sure to keep her out of jail, to do all of those things. Apparently, she doesn't appreciate that, doesn't appreciate what the court is saying, and wants to make her own rules. That's not how it works. So here's what's going to happen. Her bond is revoked. She needs to appear here. She needs to report to the Washington County Jail by 6 p.m. on the 17th of May. That is tomorrow. Otherwise, a bench warrant will issue.
Your Honor.
With no bond.
Your Honor, can I say something?
You can say whatever you like.
I am due on June 5th, and they're taking me on May 28th to have my baby. And I have been tested. I have tested since I had that diluted screen.
I don't have any tests.
Your Honor, as I said, I can send those tests to the court. This is a unique situation. Had conversations. Well, anyways, as I said, I didn't want to do anything. If there was going to be new counsel, I didn't want to do anything that, it's kind of like do no harm.
Submitted to the judge.
I'm sorry?
I thought you submitted all those papers to the judge, you and Camille, because I've been working with Camille through your office too.
Okay. As I said, Judge, I can certainly put this together as a package and send it to the court. However, there have been some issues that have come up. But if I'm going to stand that case, I would request the opportunity to do that. And before we take the drastic step of, well, there's already a bench warrant, but before I would just ask for an opportunity to do that and ask the court to extend us to.
I'm going to keep my ruling the same. Her bond's revoked. If you want to send something in, you can send it to Ms. Kirby. I will be more than happy to look at it and reconsider. But
that moment landed hard, but honestly, it was necessary. The judge finally drew a clear line after she treated the entire process like it was optional rather than mandatory. There comes a point where patience stops being productive, and this was clearly that moment. She keeps trying to talk over him and explain away months of missed testing, but he's no longer entertaining explanations at this stage. The court isn't looking for stories, it's looking for compliance. Once the judge made it clear he was done hearing excuses, the balance of control shifted back to where it legally belongs. What really stands out is how surprised she seems by the idea of real consequences. It's almost as if she truly believed enforcement would never happen, no matter how many chances she was given. Seeing that realization set in is striking, and honestly a bit unsettling, because it shows just how disconnected she was from the seriousness of the situation. That brings us to the real question at the center of this case. Do you think the judge is being fair here? Or is the 6 p.m. custody deadline too severe, given that she's pregnant? I know many of you will feel strongly one way or the other. So let me know your thoughts in the comments.
I'm not playing by her rules anymore. We're going to play by mine. I've been as lenient as I possibly can, and I'm not going to sit here and be taken advantage of. Defendant's ordered to report to the Washington County Jail, 6 p.m. tomorrow. If she doesn't report, that bench warrant goes back out, plain and simple. If you want to submit something in between time, if you guys patch up your differences and she lets you do that, that's fine. Then I'll look at it and see what I can do. But otherwise, that's my order. That's the order that will stand.
Did you say...
Thank you.
I'm sorry, Judge, just for my clarification. Did you say by close of business tomorrow?
She's got to report to the jail by 6 p.m. tomorrow. All right. That's what I'm ordering. If you want to submit something to me before then I'll be more than happy to take a look at it and hear from you and the prosecutor on it. But otherwise, that's my order.
Thank you.
This hearing was a clear example of how not to handle a bond violation, start to finish. The defendant repeatedly tried to steer the situation using personal circumstances and explanations, but the judge focused on the actual record, months of missed testing, and a lack of follow-through at a certain point. Patterns speak louder than promises. What's important to note is that the judge still showed restraint. Giving her until 6 p.m. to correct the issue wasn't punishment for punishment's sake. It was a measured opportunity to comply. That deadline reflected an effort to balance accountability with compassion, even in the face of a difficult attitude. This hearing also highlights a broader reality of the legal system. Medical conditions and personal challenges can be considered, but they do not override court orders or erase legal obligations. The system still expects communication, effort, and compliance, regardless of circumstances. Ultimately, this was a tough lesson about consequences, actions, and inaction. Both carry real-world results. Even when the situation is complicated or emotionally charged, hopefully, she's able to get everything resolved in time. Especially with a child involved, I'm interested to hear what you all think. Did the judge strike the right balance here? Or should the court have handled it differently? Thanks for watching. Be sure to like, subscribe, and share your thoughts in the comments.